Hi, this is the Business Guy. So what is a Cook Islands Trust and how can it help you from having your wealth plundered in a devastating lawsuit, divorce, or other financial battle? I'm the CEO of Lawyers Limited, and I've set up more Cook Island trusts than anybody in the world. Upon enactment of the International Trust Act of 1984, the Cook Islands became the leader in the offshore asset protection trust industry, which has led it to being one of the most highly regarded international financial centers in the world. While some might have reservations about the small island nation regarding such a title, the robust asset protection framework and professional service offerings are sure to diminish any concerns that any prospective client may possess. After all, the Cook Islands is a part of New Zealand, and Transparency International calls New Zealand, along with Denmark and Norway, the most trusted jurisdiction in the world. And if you appreciate this information, please click the like button below so YouTube promotes this video. I really appreciate it. And you can also click the subscribe button below if you haven't already, so that when more videos come out like this, you'll be up to date right away. History and economy. The Cook Islands is comprised of 15 islands in the South Pacific. The most populated island is Rarotonga, which is 2,854 miles due south of Hawaii. The islands are thought to have been settled between 500 and 1000 AD by Polynesian people who were considered to have migrated from French Polynesia, 620 miles northeast of Rarotonga. In 1773 and again in 1777, the islands were visited by British navigator Captain James Cook, after whom the islands were named. In the 1890s, the Cook Islands were aligned with the United Kingdom for fear of French occupation. The French had already taken control of neighboring Tahiti. In 1901, the islands were then included within the boundaries of the colony of New Zealand, and in 1965, the Cook Islands became self-governing in free association with New Zealand with the establishment of its own parliament and constitution. Cook Islands nationals are also citizens of New Zealand, but not the other way around. The Cook Islands is a Commonwealth nation and maintains its ties with New Zealand and the British Crown with a legal system based on British common law. In fact, the courts of the Cook Islands are based in New Zealand, and the head of state is the King of UK and New Zealand, King Charles III. The islands operate in self-governing free association with New Zealand, and English is an official and widely spoken language in the Cooks. In addition, the Cook Islands uses the New Zealand dollar as its currency. Tourism provides most of the GDP, which is supplemented by direct flights from Tahiti, Sydney, Auckland, and Los Angeles. Plus, its offshore financial services center provides a major portion of the GDP. Cook Islands Financial Services. My company, Lawyers Limited, was first established in 1906, and its current management, myself included, has been providing asset protection services since 1991, and our organization has been setting up Cook Island trusts and companies since 1996, and has set up more Cook Island trusts than any such organization in the world. Here's a list of the top 5 reasons for you to establish a Cook Islands Trust. Number 1, Cook Islands courts do not recognize foreign judgments. One of the most significant benefits of a Cook Islands Trust is that their courts do not recognize foreign judgments. A Cook Islands Trust provides protection from both future unknown creditors and current creditors. For example, a creditor can have no claim against the assets of a Cook Islands Trust if those assets were put into the trust before the creditor's cause of action accrued. That is, before a divorce, car wreck, or breach of contract occurred, if that's what created the liability. This means that a Cook Islands Trust offers unparalleled protection against future creditors. Existing creditors seeking to claim the assets held in a Cook Islands Trust are required to initiate legal action in the Cook Islands before the 2-year statute of limitations expires, making a lawsuit a matter of urgency for the plaintiff. This means that by the time a lawsuit starts and finishes and appeals are pursued abroad, the statute of limitations would bar the plaintiff from initiating a new lawsuit in the Cook Islands. If a plaintiff did wish to proceed, they would need to retain a local law firm in the Cook Islands. They would need to pay legal fees up front. Moreover, they would need to clear a nearly insurmountable hurdle and prove beyond reasonable doubt that the trust was established with the intent to defraud them, and not just any creditor, but them in particular. All of which produces a lengthy and costly process for a creditor that will almost always induce them to abandon or settle a frivolous claim. And those are some of the reasons why we've never seen any of our trust clients face lawsuits in the Cook Islands. Reason number 2 for forming a Cook Islands Trust is estate planning advantages. While asset protection is often the main objective of a Cook Islands trust, estate and succession planning is a significant advantage to the jurisdiction. With no rules against perpetual trusts, a Cook Islands can last indefinitely, unlike most jurisdictions, if a settlor wishes to do so. This makes it a great legal vehicle for both immediate and long-term estate planning purposes. In addition to this, foreign inheritance laws such as forced heirship are not recognized in the Cook Islands. That is, some jurisdictions force you to pass your assets on to certain members of your family upon passing. But in the Cook Islands, you get to decide. The terms of the trust that you dictate determines who inherits your assets. With these advantages, a Cook Islands trust can benefit multiple generations in perpetuity. Number 3, tax benefits. Residents of certain jurisdictions may be able to retain a tax benefit from establishing a Cook Islands trust either during their lifetimes or after death. Now, the Cook Islands does not impose taxes on international trusts or their trustees. This means that a Cook Islands trust is not subject to any local taxes such as gift, income taxes, estate, or capital gains. It is, however, vital that anyone seeking to establish a Cook Islands trust obtain specific tax advice from a local accountant to ensure that they are aware of their tax and reporting obligations wherever they are a tax resident. Benefit number 4, protection for a variety of asset classes. Medical practitioners, lawyers, developers, business owners, and others may be at risk of future claims that have accumulated significant wealth, may have gathered that wealth in a diverse range of assets. One can use a Cook Islands trust to protect a number of different assets, including tangible assets such as yachts, vehicles, real estate and bullion, and intangible assets such as investment portfolios, digital assets, company shares, intellectual property, bank accounts, and life insurance policies. We often use equity stripping strategies for domestic assets to strip their value, since they are often under the jurisdiction of your local courts. Benefit number 5, exposure to global financial centers. A Cook Islands trust that we established for you can connect you to our network of financial service relationships across the globe. For example, your trust can hold a Cook Islands account or a Swiss account or both, providing international bank accounts with numerous banks and SEC registered investment advisors, allowing access to global investment markets guided by recognized investment advisors or index funds curated to preserve or build upon your wealth. Conclusively, a Cook Islands trust offers many benefits, and people looking for the highest standard of asset protection will certainly find it in the Cook Islands. If you'd like to inquire about establishing a Cook Islands trust, please don't hesitate to contact us by filling out a free consultation form at assetprotectionplanners.com. From the enactment of Cook Islands trust legislation, a framework was established to continue developing and maintaining professionalism from within the industry. The Financial Supervisory Commission, FSC, is the regulatory body that both licenses and regulates the trustee companies, international banks, and other service providers that operate within the Cook Islands. To supplement the asset protection structures it offers, the Cook Islands hosts a full service, including private banking services, which was established in 1997 to provide bank and investment services for the entities the Cook Islands provides. In fact, our investment services provide both self-directed trading accounts and managed investment accounts as standard offerings. The bank in the Cook Islands offers transactions across the globe and maintains a capital adequacy ratio that exceeds Basel III requirements, which measures a bank's financial stability. Now, at times, potential clients or partners can hold concerns about the Cook Islands, particularly around the sheer amount of physical distance between themselves and the trustee. However, it is important to note that by engaging our reputable trustee/law firm, the history of the industry, and the nation itself, you can feel secure that your wealth is safe and truly utilizing the utmost in asset protection benefits of Cook Islands legislation. If you'd like to inquire about the products or services mentioned in this video, don't hesitate to contact us now at assetprotectionplanners.com or call us at 1-954-400-1050. Please like, subscribe, and share this video with others. See you next time. This is The Business Guy.